Hello, this is U.S. Immigration Attorney Sharifa Tharpe. I'm here live to take your U.S. immigration related questions. Put your questions in the comments now so that I can answer your questions. So, I have a good topic for you today. So, oftentimes I'll get the question. Someone will call and they will schedule some time to speak with me. They're here on an H-2B visa, for example, it's like a work visa for seasonal workers. So they're on the H-2B, and they go ahead and they ask me if they can get the work permit. I know if you don't have an H-2B and you're hearing that they're already here on a work visa, you're thinking, if they're already here on a work visa, why are they asking if they can get a work permit? Well, the reason is here is if the person has an H-2B visa, they are only sponsored by an individual business. When they come here on the H-2B, they don't get a physical card in hand that says they are authorized to work for everybody, because work permits do allow you. Now, work permits have no restrictions other than the expiration date. So, work permits allow individuals to go anywhere in the country, to work for anyone, to do any kind of work, to start their business, to work for others. So, the work permit is very flexible. However, having other types of work visas, like, for example, H-1B, H-2B, those and H-2A, those only allow the individual to work for the sponsoring employer. So oftentimes, when someone comes here on, say, the H-2B, they are either unhappy in the kind of work, and you'd be so surprised how many people are unhappy in the type of H-2B environment that they're working in for that employer. And they are trying to find a way out. And so they come to me and they ask what are their options to get the work permit. And this is, of course, where I do have to evaluate their circumstances. It's not that they can't get a work permit, but before they can apply for a work permit, they still do need to qualify for a work permit. So someone coming on an H-2B visa is not automatically entitled. Oh, thanks so much. Happy International Women's Day. So I wasn't even paying attention to what day it is. But same to you. Thank you so much. Now, in this case where they are here on the H-2B and they want to then go get a work permit, then the next thing I do is I have to evaluate, what do they have family members here that could do this? Is the employer, especially if they're here on current H-2B status, so they're currently working for the employer, then it's, well, have you had a conversation with the employer? Has the employer expressed any willingness to sponsor them directly? Unfortunately, some employers will not, because the reason they're very happy with the seasonal arrangement of the H-2B, but sometimes an employer may want to take that next step. So it is worthy to explore that option. Of course, it's based on an employer-employee type of basis, on a case-by-case basis, to determine whether that's an option for you. Because if the employer gets started on your paperwork while you're working for them, then it is possible that you could then obtain the work permit while you're going through the green card process with the employer. So if you qualify in other ways, though, you can qualify for the work permit. So the next question then I ask are, let's look at some alternatives. They don't have family, an employer isn't willing to take that leap to sponsor them to be able to get the like a permanent type of residence. Then and when I say permanent residence, what happens is while they're applying for permanent residence, they can get the work permit. Now, of course, keep in mind that you're going to have to, when it's employment based, you're still going to have to work for that employer. But with a work permit, you may be able to pull two different jobs because you're not restricted on working only for the employer with that work permit. But you still, to be able to get permanent residence, you still have to show that you are working for the employer and you have to work for them, continue working into the process and possibly after, because you know, the immigration is going to pay attention to whether you stay in the job after you get the green card. Otherwise, they can construe it as fraud. But that is a topic for another time. Now, if they don't have an employer, don't have family member, then the next thing I explore is why, if you are working, you know, for this employer, working in this industry, usually it's in the hospitality industry, um, so restaurants, hotels, cleaning. um, I oftentimes check to see what's going on with the employer. Is the employer mistreating the person who is seeking my advice, so the H-2B holder? And if that's the case, the T status is not it's not off the table as an option. So, and you would be very surprised how much employer abuse happens um, in the H-2B program. I do have clients who have very strong cases, and they came in as H-2B holders, visa holders, tried to do everything right, and still were mistreated, underpaid, not given enough hours, kept in deplorable conditions. And as a result of that, they either had to escape the situation or they had to remain, but they are now working with me to figure out the best solution to go forward. And the T status is the best option here. So if you are in a situation where you have the H-2B visa, I'm pretty sure you may feel like, okay, but this is the person that I have to stay with them. That is not true. There are still very specific rules that you have to follow. Now, one of my clients was very wise and very savvy. And the way that she realized that things were not the way they should have been was by having the handbook. So there's a handbook that H-2B holders can use to look at their rights, because abuse is so prevalent in that area in the H-2B program. Employers can try their luck with telling employees, H-2B holders, all sorts of things. And so by looking at what her rights were and comparing it to what the employer was doing in reality, she quickly realized that she qualified for the T. I mean, she didn't confirm it until she spoke to me, but she knew something was wrong. And based on following me and listening to what I had to say, she knew that she had to talk to me about it. And we have gone forward with pursuing assistance for my client. So, um, you know, not because you're in legal status does not mean that you don't qualify for T. You could still have legal status on a certain type of work visa, but that employer took you here to mistreat you, to abuse you, to exploit you, and they did it under false pretenses, promising you one thing through the H-2B program, and when you arrived, that wasn't the case. So that is very important to understand, that it's not just, you don't have to be undocumented to qualify for T status. As long as you're in a situation where you were brought into that situation through false pretenses, we refer to it as fraud, or even through coercion, where they start to overwork you, underpay you, start to yell at you, start to talk about your immigration status, start to tell you they act as if they own you because they are the ones that sponsored you. If you start to experience situations like that, you know, you're doing work that For example, with one of the traffickers, they sent people out. They hired them to do one thing, but when they came on the H-2B, they sent them to do other work duties that were nowhere listed on that approved petition that they should be doing that kind of work. So, and that's fraud. So in that case, you can qualify for T status. Let me give you a short rundown of what the benefits of T status are. So the T status does provide you a work permit. And with a work permit, unlike the work visa, you are able to have flexibility to live and work anywhere you want to in the United States with that work permit that you get. Now, that you get that 4 years, generally you can apply for your green card after 3 years. But not only do you get the benefit of this, your family members can get the benefit of this. So if you are under, if you were under 21, if you're under 21, then your parent can be on the petition, your spouse, your children who are under 21 and unmarried, and even your siblings who are under 18 and unmarried can qualify for the T status along with you as derivatives. They don't have to be victims, they just have to be related to you in that way. If you are over 20, 21 or over, your spouse, your children, your stepchildren can, and qualifying stepchildren. When I say stepchildren, you have to get married to your spouse before that stepchild turned 18 to qualify for this. But it extends to your relatives as well, these qualifying relatives. And even if your relatives are outside of the United States, even if they're here undocumented, they can still qualify. So, and don't worry. Now, if you yourself have had issues, say you had an arrest in your past, maybe a conviction, keep in mind that there are ways to ask for forgiveness for forgiveness for those at the same time that we're asking for the T status. So don't count yourself out. Speak to me first. Let's talk about what your options are and then decide if it is best for you to move forward with applying for the T status. I think it's very important to bring this to you because so many people out there are experiencing issues like this, and you think you don't have any rights, you think you don't have any options, so you continue to live in this abusive environment or you continue to be exploited. So I just want to let you know that there are options here. Even if you're currently on the H-2B visa and the employer is not treating you right, it's time to check it out. Time to check it out now. Another thing to take note of is that the T status is for victims of trafficking, but you have to be present on account of the trafficking. So for example, I've seen situations where the H-2B employer, they realize that they are, compromised, that maybe the employee is very outspoken, talking about their rights, rallying everybody to join them in, advocating for their rights to the employer. So what happens? The employer quickly fires them and then tells them they're buying their ticket right away to send them home the next day. That can be an effort on the abusive employer side to cover up what they've done, the fraud, the coercion that they've done, and to get you out of their hair and out of the country so you can't return. So before you jump and do that, if you know that you have experienced exploitation, mistreatment, coercion, fraud, don't just jump on that flight and head out at the order of the employer. Make sure you stop, you get legal advice for yourself because that employer is looking out for themselves. They may not necessarily be looking out for your best interest. So if you want to look out for your best interest, before you take any actions recommended by the employer, make sure that you first urgently consult an attorney. And you have to find the right attorney, by the way, because if you choose the wrong immigration attorney, they're going to say, "What? Get out of here." Because remember, there are not a lot. I know it should be that way, but unfortunately, there are not a lot of attorneys, immigration attorneys, that practice in the area of the T visa. So this is very foreign to a lot of immigration attorneys. It shouldn't be, but unfortunately it is. And so reading the basic language and instructions of the T visa, especially on the USCIS website, it seems like it is extremely restrictive, and it's, you have to be in the middle of an investigation, suing the employer, somebody has to be arrested, and it does not necessarily have to go that way. So you have to find the right attorney, which of course that is going to be me in this case. But go ahead, schedule, call, and let's talk about your situation as soon as you're experiencing it, as soon as you have that gut feeling something isn't right. Call me and schedule some time and let's talk. So it's both me and Attorney Bria that are working on evaluating cases to determine whether you qualify for a benefit that we can help you with. And it's important for me to have an attorney help me because my schedule is getting so booked out that I do need another good attorney who I can work with closely to evaluate cases. So you can schedule with me, you can schedule with Attorney Bria, and we will talk with you and determine what the best course of action is, whether you qualify to move forward with the T status. All right, so I've said my piece. Now, if you want to, I think I've seen people say, so I think I've seen some people say they want to get in touch with me. Go to the link in the profile or go to the description of the video on YouTube, Facebook, and Twitch. You'll see the link. Take that link and it will take you to Linktree, where you can click to schedule your appointment with either me or Attorney Bria, or you can call the office, go to the website, call the office, and staff will be more than happy to speak with you and help you to schedule that appointment. All right, so now that I've said my piece, I'm going to answer some questions here. So let me go here first. I'm on TikTok first. So please, I'm going to jump from one platform to the other. So, it's beneficial to you to, of course, hear the answers to other questions, but I'm going to make my way around. So today I'm starting with TikTok. I'm going to scroll through and answer these questions. Afternoon. VAWA was approved this month. How long before the green card is approved? So I would say anywhere from 6 months to a year and a half to get that green card. Now, they may schedule an interview or they may waive the interview. I came through the border, got married, an interview coming up next month. So what's next? So if you came through the border, whether you are going to succeed here is going to depend on whether you were paroled into the country. Because when you are going through a family-based or marriage-based adjustment of status, one of the very important criterions of the adjustment of status is you have to show that you came into the country with some form of permission. Now, this can get complicated, and I really do hope that you have an attorney. Reach out to your attorney, talk to the attorney about preparing for the interview. Because in cases where I've heard that the individual has crossed the border, I have to determine what is the nature of the admission that you are granted. That the reason being, not everyone who comes through gets processed through the border is considered admitted for purposes of immigration. It's very important to understand that. So you may have been permitted to come in, but they may not have stamped a parole in your passport, or they may have not given you an I-94. They may have just said, expect the notice to appear to come in the mail. And when it comes, then you have to go to court. In that case, where you didn't get a parole, you didn't get an I-94 stating that you were paroled, then it means you were not formally admitted. And it's likely the next step is they are going to refer you for removal proceedings. So that's the first thing. Now, if you were paroled and you were given the right kind of parole to enter the country, then that is considered acceptable for purposes of the adjustment of status to get your green card while staying here. So, make sure that you get the right legal advice, so you understand how to approach this when you're going into the interview. Make sure you talk to your attorney. What is the next step when you file anonymous complaint with the NYDOL? So it depends. So if you file it anonymously, it just depends on how you're approaching the complaint. Anonymously usually means that maybe you call the hotline and you just gave general information. I would not be able to tell you what happened there on the Department of Labor side, because I don't know how much information was given. And since it's anonymous, it would be very hard for the Department of Labor to get back in touch with you to do follow up. They may accept the report, but they may not. They're not going to necessarily follow up, say, regarding any kind of wage and hour violations. So it's hard to say what the next step is at the Department of Labor. Now, if you're doing the T visa, you do have to show proof that you have filed this complaint or this report. And if you have, then at that point, it can be used for the T status. I made a mistake on reapplying for my work permit by putting my last name, not my marriage name. So that's more of a typographical error. You have to get in touch with them and make that correction. How do I contact you? I want to discuss T visa. So if you scroll to the top of this, you'll see my number, but you can call 561-405-4889, or go to the link in the profile, schedule your appointment, and then we can talk about it. Can a person have a work permit while their I-130 is processing? No. It has to be an adjustment of status application. Is there interview for green card asylum based? There may be. Yes, if they have questions, they're going to schedule an interview. So an interview is possible for all types of adjustment of status to get the green card. They're waiving many of them, but if they have questions, they're going to schedule the interview. What if H-2B visa is expired? It doesn't matter. If H-2B is expired, is current, if you're experiencing any kind of mistreatment, fraud, coercion by an employer, we want to talk to you to figure out if you do fit within the criteria to get the T visa. Can you get a green card if you have parole that expired 60 days, also have an eviction and repo? It's possible, but I would have to understand more. Who are you? Who is petitioning for you? How are you applying? Are you self-petitioning through VAWA or the T visa? These would be important things that would have to follow up on here. Can I get a work permit while on a visitor's visa? So also a very common question. The general answer is just by having a visitor's visa, you can't get your work permit. So you're coming in with your visitor's visa. Think about it. You're coming in with a visitor's visa, guaranteeing with your visitor's visa, just by entering, that you're not going to work. You're here to visit, or you're here for maybe short business like a meeting or a conference. You're not here to work. So just by the condition on your visitor's visa, it means you cannot get a work permit. However, I have represented clients who have come in with their visitor's visa, and when they came in, something happened that then qualified them to get their work permit through that benefit. So, for example, they came in with their visitor's visa, ended up being recruited by a trafficker to work, and then as a result of that, we're able to get them T status, and they got the work permit. So, the having the work permit, getting the work permit if you came in with a visitor's visa is just because there's something that now qualifies that person to get it. File for my husband since 2021. I have a green card. How long more will it take? So it depends on where you are in the process and where your spouse is right now. That is kind of long. So we'd have to understand though, is it adjustment of status? Is your spouse outside of the US? SIJS priority, February 2021. So I know the priority date is based on the category of the immigrant, the juvenile immigrant. I haven't checked the visa bulletin on that, but you'll have to check on that. So you can go to the visa bulletin to check that priority date based on the age of the child. What is the next step when you file an anonymous complaint? To answer that, are there any updates on the CR1? So this is conditional residence for the spouse, visa processing time. No, but you'd have to check. It depends too. Are you the spouse? Because CR1 usually means you're getting conditional residence, and you're the immediate relative of a U.S. citizen. So, um, you know, based on processing times, I'd have to um, understand your process, get more facts to be able to tell you what those processing times are. All right. If you want to start, if you want to start content creation on social media but haven't been settled with proper documentation with USCIS, does that affect you negatively? No, not necessarily. It just depends on what you're applying for. As usual, you have to be careful with any kind of public postings and social media accounts because they do research on you, and a part of that research is they check your accounts. So if you're a content creator, that means that you are publishing content out there that they can look at, and they can compare the information that you're providing in your social media to your application. And so, most if not all of my clients have nothing to worry about because everything is usually consistent. But you have to make sure that you understand that they're going to look, and they're going to also use it as a way to verify some of what you've put in your application. Can I apply for a change of status with the VAWA case after 15 months? Two steps, one, prima facie. So it is your priority date current. If your priority date is current, then at that point you can apply for adjustment of status. But you have to wait for it to show as current. Uh, Happy Friday. If you have a work permit and I am working for this employer, can they file for the green card? Now, if you have the work permit, it's complex. Now, work permit does not give you an official status. So if you have the work permit, based on maybe you're applying for something else, and they give you the work permit while you're applying for that something else, it's if you've overstayed, then it's very unlikely that that employer is gonna be able to petition for you. So you're in that type of gray area here. Work permit does not give you the status you need for an employer to sponsor you. Um, how you know your priority date is current? Oh boy. It's so complicated, and it's a bit abstract. So there are different charts and categories on the visa bulletin. So you can Google it. It's on the Department of State's website. And now each category you have to look up, you have to read every line, read the instructions. Each category is representative of a category of immigrant. So, for example, the son or daughter, age 21 or older, of a US citizen who is unmarried. That one is called the F1 category under the family section. If you look there, you'll see some dates, and sometimes you'll see a C. If you see a C, that means it's current. If you see a date, then you have to compare it to the date on your receipt notice, your petition receipt notice. It usually puts priority date. You have to look at your priority date and then look at the date on the chart. And if the date on the chart comes on or before the date if your date on the petition comes before the date listed on the chart for your category and your country, then it means that your priority date is current, and you can either file adjustment of status if you're here and you are maintaining your legal status. You can file adjustment of status, or you'll start to get correspondence from the National Visa Center for them to start processing your visa paperwork. So that is the how you find the priority date is current, and that is a very, very a more watered down explanation here. So there are different charts that you also have to know which one to look at to know whether it's current. So if your employer refused with your money and you're afraid to claim for a green card through that because he might do something bad to you, what should you do? Give me a call. That's what you should do, because we deal with these issues regularly, and we can tell you how to move forward in a confidential way to be able to get the relief that you need. These are all great questions. So I'm here on Instagram. Thanks so much for your patience. Make sure you put your questions in the comments so that I can go through. Happy Friday. Thank you. Are there any chances of getting a work visa from outside as a civil engineer? That's possible. So you do have what's called the national interest waiver. So if you have your advanced degree, your master's or your PhD, or you have your bachelor's degree in civil engineering with 5 solid years of experience, then you could possibly qualify for the national interest waiver. So the national interest waiver, once you've determined that you do have that advanced degree, you have or you qualify in regards to education level, the next thing is to determine what your goal is coming to the United States. That's going to be very central to this. You have to focus on your goal. Your goal has to be clear here. What do you plan to do with your civil engineering experience and your degree, your level of education? That's the basic idea of what they want to see in the presentation of your application. So there are three requirements here. So one is that you do have to show that you're going to come here to achieve a goal of national importance and substantial merit. Doesn't mean you have to invent anything, doesn't mean you have to be famous or you have to have any huge national awards or anything like that. But it does mean that you can show how you're going to use your experience to target something that's very important nationally, in the United States, that's going to benefit the United States. That the next thing is to show that the you have the ability, you have the means to achieve that specific goal. um, the means to achieve that specific goal means that you're going to show your experience, you're going to show who you've worked with, you're going to get letters of recommendation, articles you've written, innovations of yours that you've already created, to be able, maybe businesses you've run outside of the United States already, major projects you've worked on. You're going to show how your experience, in a nutshell, can help to achieve the goal of national importance and substantial merit. And then the last one that you have to address is, why should the United States not just require an employer to petition for you? Because remember, usually an employer has to do this for you. So you have to show then, how is it going to benefit the United States to just waive that requirement that you have an employer do this for you, and that they just give it to you directly. And so with that one, you definitely have to show, possibly, if there are a shortage of engineers, civil engineers in the country, and it has become an urgent issue, you can show that. Now, through, of course, you can use expert opinions to show this. You can show studies, and other types of literature and sources to show that your qualifications is definitely a much needed benefit that the government needs right now, and so they should waive the requirement that an employer sponsor you. Because if the employer sponsors you, it could be a 2-year process, versus the national, right now, priority dates, they were all current before. Now they're not. So there is a wait list for many of the countries for the national interest waiver, but it may go faster if you petition for yourself. So yes, that may be possible with a civil engineering degree, in a nutshell. All right. How easy is it for someone to apply for an EB2 visa who has master's degree and about 10 years of experience? So I just explained that to you. So that's a national interest waiver, everyone. If you are interested in it, if you're interested in using your education, your experience to come to the United States, that's going to be the national interest waiver. Can you use the national interest waiver to fix your status if you're out of status? No, you cannot, unless you qualify for a waiver, but it's not going to allow you to stay here in the US and get the green card. So that's just to answer that question, because sometimes that does come up, is will that help me to fix my immigration status? I'm a British citizen, arrived on J1 extended to B2, soon out of status, but married as US citizen. Am I okay to apply for AOS? So I would want to just make sure that you have nothing. So with the J1, for example, there's a 2-year foreign residency requirement. And so you just have to be very careful that that's not there, because if it is there, then you need a waiver to move forward with the adjustment of status. If you overstay on H2B, what's the best option to get a green card without marriage? So, I did mention, for example, if you overstayed, but the reason you overstayed was somehow related to your mistreatment and abuse, exploitation by an employer, that could be a way to obtain T status. And the T status does eventually lead to the green card, but I would have to understand your facts here. If that was not the reason you overstayed, just overstaying on the H2B alone isn't going to get you the green card. You have to qualify in some way. What's the number? So go to the profile page, you'll see the number, but it's 561. Let me see, let me type it here. 561 405-4889. Call and they'll be more than happy to help you too. And it's under immigration lawyer Sharifa. All right. Let's see if we have any more questions, and then I'm gonna head out. Can you travel to another country with a parole paper? Yes, if you have advanced parole, it's possible, but your level of risk is going to be determined by your particular circumstances. How can I get a work permit? So the work permit, you have to qualify for one of when I do the consultation, I evaluate whether my the person qualifies for different options. So I go through a list of the options that I pursue for my clients and to determine whether they can get to the work permit by qualifying for an immigration benefit or form of relief. Do you have to prove more documents when filing for citizenship, especially when you don't have any new documents? Um, so I don't know what context that would be in. If it's a marriage, now citizenship is when that's the ultimate. You're already a permanent resident and you're applying for citizenship. In my world, it's very different. Citizenship and getting the green card. So please make sure that you can tell the difference as well, because I have known people to get into a lot of problems saying they're citizens when they're not, because they don't understand the full extent of making that error, of making that not distinguishing between the two. So in this case, for marriage, so citizenship, I'm thinking green card for based on a marriage, and that might be you are applying for removal of conditions. So you're going from a 2-year to a 10-year. That's usually the time when you have to provide updated evidence about your marriage. So that's what I'm thinking about. So it's not citizenship. It is a 10-year permanent residence based on okay, got you. Exactly. So you're going from 2-year to 10-year green card, and you are trying to figure out if whether they will take the approval on the old evidence versus the new. They will not. They expect you to submit new documents showing that in the last 2 years, that when you've had your green card, since you've had your green card, now you have your green card, what new have you done with your spouse to prove that you are still in a bona fide marriage? Have you filed taxes together? Then that could be updated evidence. Have you moved to a new location together? That could be new evidence to show that you continue to build life as a married couple to get that tenure. Now, here's what I don't want you to do. Don't try, if in cases where you don't have any new evidence, um, in cases where you don't have new evidence, do not try to pretend as if you remain married. You don't have new evidence because maybe you're separated from this person. Do not try to pretend as if you're still married to see if you can get through the process, because I can guarantee that's can be a recipe for disaster. If you're no longer with your spouse and you are applying for the 2-year to the 10-year, you need to submit a waiver or they will deny your application. So make sure you apply for a waiver. That waiver allows you to apply without the spouse based on exactly. So if you are no longer together, you cannot get citizenship based on that 3-year rule unless you got mistreated and you're applying for a VAWA waiver. You get approved for the VAWA waiver, and yes, VAWA waiver is also under the 2-year conditional green card, where you're removing the 2-year. If you were mistreated, you got approved, you can apply for citizenship still within that short 3-year period. But if you go through the process trying to pretend as if you're still married to the person and you completely disregard the fact that that you're not together anymore, that's a recipe for disaster. They can accuse you of fraud, misrepresentation. They can deny your card. So make sure get legal advice. Can't stress enough. I mean, I I would definitely have to give you more extensive advice here. And I've seen time and time again where people make mistakes thinking they have to pretend their way through the process when it's just easy to tell the truth and say what happened. Can can I 130 prove a bona fide marriage for VAWA? Yes, it can. My husband and I just moved into a new apartment, but they didn't allow him to put my name in the lease because I don't have an SSN. What can I do in this case? So there are other ways. If you can't go on the lease, there are other ways to show that you live together, and that's going to depend on your circumstances. Do you get mail together? Do you have joint bills showing the same address? Do you have someone else who can verify that you live at that address? Do you have roommates who a roommate that can sign off verifying that you live there at the same time? So those are just some examples. If your priority date is current, you are in your home country, but you plan on traveling next month to the US, can you apply for AOS once in the US? So be very careful because remember, you're not supposed to be coming. Like, you can't look at your computer and say, oh, look, the priority date is current. I think I'll just fly into the US and apply for adjustment of status the next day. Immigration just does consider this to be fraud. Because at the time you entered the United States, you had the intention to apply for adjustment of status, even though your visitor's visa prohibits you from doing that. So, what you have to, in this case, of course, people can come to the US and change their mind. So I would say, if you're in the United States, this is where you get legal advice about whether you can qualify at that point to apply for adjustment of status, and make sure you understand the implications of that first. So definitely schedule an appointment and let's talk. All right, so that's going to be it for me today. Thanks so much. Can you get a green card from F2A without leaving the US? It's possible, but here's the tricky part. You're an F2A. Do you have your current status? Is your priority date current? If you meet those two criteria, then you can qualify to get your adjustment of status while being here. But you have to meet those requirements. So make sure you get legal advice. If it's not clear, that's where you get legal advice. Is it safe to travel with advance parole after removal proceedings get dismissed? This you need to definitely make sure you talk to your attorney, you get legal guidance. Definitely do not leave the country until you get that. That's going to be when I advise my clients about travel, I really do it on a case by case basis. And if you've been in removal proceedings, it means that you're at an advanced risk of something happening. So can I adjust status from T to diversity visa? No. And if you're here in the United States and you're out of status, the diversity visa will not work for you. All right. So thanks everyone again for your time. I really appreciate it. I will see you on Monday. So I'm going to work to get here at around lunchtime, which is between 12 and 1, so we can continue talking. I'll come and bring some updates. There are a number of things going on right now. So Congress, as you can see, Congress passed, or maybe you haven't seen it, maybe you're hearing it from me. Congress has now passed, well, not Congress, but the House of Representatives, this is at the federal level, the national level, has now passed legislation that would allow local law enforcement to detain an immigrant who has been an undocumented immigrant who has been caught doing theft or shoplifting. They can be detained and then referred for deportation. So keep that in mind. And then the other is that Georgia is doubling down on their bill. So it's still a bill, still proposed law, same at the federal level. But now they're also targeting safe havens for immigrants, the safe harbor cities for immigrants. Now they're saying if law enforcement or if any cities, create a safe place for immigrants, undocumented immigrants, they're going to defund those towns, those cities, and they're going to remove the officials. So we have to see where that's gonna go as well. But keep in mind that there's a lot going on, and we all have to stay vigilant and just understand what's going on, the implications for you, and make sure you figure out your immigration options. Invest in yourself, invest in knowledge about your options. All right. So thanks so much, everyone. I come back with your questions on Monday. All right. Thanks so much. Have a great day. All right. Bye bye.